Good day, everybody. This is Sam Shihab.
I'm Brian Burke.
Today we're going to be talking about change of employer with green card process, with the lengthy processing time for a green card application in the US for certain countries such as China and India, exceeding a decade. A change of employment sometimes is inevitable for circumstances beyond your control or your employer's control. What we want to talk about today is what scenarios and during the process that your certain rights are preserved or not preserved. We're going to go through a PowerPoint presentation quickly, and then we'll be taking questions. All right, so the first thing we're going to talk about here is during the PERM labor certification. Before we're going to be defining what is a process.
Yeah, so I mean, we're talking about change of employer. What's a change of employer? It's voluntary changes. It's, gee golly, I want a new job. Or involuntary changes, the employer terminates you, or the employer goes out of business. Something happens to them. And when we talk about the green card process, we're going to actually talk about all the three major steps in the green card process, being PERM labor certification, the I-140 immigrant petition, and the I-45/adjustment of status. So we're going to cover everything, something for everybody here.
And each process, if the question is if a change of employer occurs during the PERM, after the PERM, during the I-140, after the I-140, during the I-45, and we're going to take all the scenarios, probably 12 or 13 different scenarios. And we haven't covered every scenario, but we've covered most common scenarios. So with the PERM labor certification, if the PERM labor certification is filed and there is a change of employer at any time before the PERM process is approved, or during the waiting period of the prevailing wage, if you're in recruitment, if the PERM filed and pending with the Department of Labor, the end of employment or change of employment or termination of employment terminates the process. So if the PERM process terminated, you receive no benefits, no priority dates, and no ability to extend your H-1B beyond 6 years. You obviously get your normal H-1B extension, but not beyond 6 years.
Yeah, so next sort of milestone you hit is when your PERM is approved, and that means the Department of Labor has certified the labor certification, your PERM, and you're eligible to file an I-140. But ultimately, without the I-140, if nobody files that I-140, if the process is terminated after the PERM is approved, if nobody files that I-140, you don't get to keep the priority date, which was established the date of your filing of your PERM, and that's pretty much the end of the road there. No ability to retain that priority date, use that PERM to extend your H-1B. Well, I say that, Sam. I got to point out it's always possible to negotiate. There's no requirement that you be currently employed with your, the company that's filing for your PERM or your I-140. So it's worth noting that you can possibly negotiate, that, hey, I'm willing to come back to your company later. Please keep my green card process going for me.
Well, that's an excellent point. Maybe we can pause and talk about there must be a bona fide job offer.
Yeah.
And the employer has an intent to hire you at the time of the green card approval. It is not today. It's at the time of the green card approval, which is many years into the future. So you can tell the employer that, hey, maybe you don't have an assignment for me now, but if you're confident that you're going to have an assignment for me in the future, I will continue to commit to you, and we can keep the green card process.
Yeah.
But if during the PERM process, the employer withdraws the PERM application, there is not a priority date preserved, which is a priority date is a spot in the line for you to get your green card. Yeah. So if somebody gets a priority date a day after you, you have 1 day ahead of them to get a green card. And that's why that priority date is very critical.
So executive summary, PERM approved, nobody pursuing it further, you're not going to be able to use it for anything.
Yes. Change during the I-140 process. Now, when we say that, we're saying that the PERM labor certification has been certified, and now we're talking about the time after the PERM labor certification is approved. So effective termination, if the I-140 is not approved, So filed but not approved, and then there was a termination of employment and a withdrawal of the I-140, you do not receive the priority date, and you cannot use the I-140 to extend your H-1B status beyond 6 years.
Yeah.
If the PERM labor certification, I'm going to repeat that, if the PERM labor certification is approved and there's a change of employer after the PERM is approved, before the I-140 is filed, or during the I-140 being in process, meaning filed but not approved, then you do not keep your priority date and you cannot extend your H-1B beyond 6 years.
So once the I-140 is approved, things start to get interesting. If you have your I-140 approved, that means USCIS issued an approval notice on your I-140 petition. You all sorts of benefits. You get to keep the priority date that was established by the filing on the date of the filing of your PERM, and the employer can withdraw your I-140. We're talking about a specific scenario here. If your I-140 is withdrawn, if they terminate your employment and they send off to withdraw your I-140 within 180 days of approval, the employer can do that, but ultimately you get to keep your priority date. The I-140 is considered withdrawn, and you can't use that to extend your H-1B status.
Beyond 6 years.
Beyond 6 years. You can always get your 6 years worth.
Yes.
Gets more interesting though, Sam, after 180 days of I-140 approval.
So the I-140 is approved and 180 have elapsed.
Mm-hmm.
Okay. So what happens if there is a change of employer after that? Obviously, the priority date is you can get to keep it, and the employer can withdraw the I-140 after 180 days, but that I-140 withdrawal is really not effective, meaning that for the purposes of the H-1B extension beyond 6 years, and for H-4 EAD,
important.
Yeah, you can continue to receive these benefits even though the employer withdrew the I-140 after 180 days.
Yeah, I mean, it should be noted that you still have to find a new I-140, a new permanent employer in the United States to actually, pursue a green card.
Yes.
Yeah.
So maybe we need to point a couple things that is not in the slide, but it's probably a good point to kind of bring it up.
Yeah.
An I-140 revocation by USCIS for fraud or misrepresentation invalidate the priority date.
Yeah.
So that's something it happens at any time during the process. If there's fraud or misrepresentation in the I-140 and there was a revocation of that I-140 by USCIS, then it invalidates the priority date.
Yeah.
Other than that, you keep your priority date.
Yeah.
All right. Now I-140 is approved.
I have this one. This is I want to before we even get to I-140 approval. There's a scenario of I-140 and I-45 pending together.
Right.
Yeah.
So go ahead.
Well, as a lot of people saw back in October, they allow you to file your I-45 and I-140 at the same time, and well, that's great. You get to file your cases together. But what happens if they withdraw your I-140? If right after that happens, your case gets withdrawn. Well, a lot of bad stuff. It's you don't get your priority date because the I-140 is never approved. You don't without that approval, you don't have any ability to extend. You never get that benefit of keeping that I-140. Never approved I-140. You can't extend your H-1B status based upon it, and your I-45 is going to be denied as well.
Right. So kind of recap this scenario. We have an I-140 pending, and then the priority date visa bulletin is released, and your priority date is current. So you move and you file your I-485, and the I-140 is now pending with USCIS, not approved, and there is a change of employer, and there's a withdrawal of the I-140. That's the scenario we're talking about. So obviously, I-140 is not approved, no priority date. I-485 hangs on the I-140 or builds on the I-140, right?
Yeah.
So when the I-140 is withdrawn, because prior to being approved, I-485 is denied. The EAD and the advanced parole that comes with the I-485 are also will be denied as well. And you cannot extend your H-1B beyond 6 years, and you hope to keep your H-1B status because you cannot terminate your H-1B status and work on that EAD, because if that scenario happened, you got to leave the country.
Yeah, I think I'd point out that it's only the withdrawal of the I-140. Your employer can withdraw your I-140, and that's their decision. On the case, it's kind of a trickle-down effect that all those the I-485 and the associated EAD and AP get denied by USCIS. So
yes,
they can't touch your I-485, but they can definitely touch the I-140.
Yes. All right. So now we go to the next scenario, and the next scenario during the I-485 process as well, and you have an approved I-140 now, and a pending I-485.
Yeah.
In addition, you have an I-140 that has not been approved for 180 days. So it's less than 180 days on the I-140, okay? Approved, but not for 180 days. And the I-485 pending less than 180 days. So this is the scenario we're talking about.
Yeah.
So what happened here? Obviously, I-140 is approved, but less than 180 days. Because it's approved, you've locked your priority date. So that's for sure. Now, if there's a change of employer during that time, what happened is that you cannot use the approved I-140 that's been withdrawn to extend your H-1B status. And your I-485 will be denied because the employer withdrew the I-140 within 180 days.
Yeah.
So this is really critical to know that if you change employer or if you lose employment within the 180 days of the I-140 approval and within the 180 days of the I-485 processing from the date of filing, that is a time where a change of employer can derail the entire process for you.
So next scenario is a lot more interesting for sure. So we're talking about your I-140 is approved and your I-485 is pending, and the withdrawal of the I-140, the termination of employment comes 180 days after the I-140 approval, but within 180 days of the I-485 filing. So because your I-140 is approved, you keep your priority date, and because you're after 180 days, your I-140 approval survives, meaning you can use it for that H-4 EAD and to extend your H-1B. But what happens to your I-485 is a great big question mark, depending on really where your priority date is. If your I-485's priority date is current, USCIS expects you to have an offer of permanent employment in the United States, and they can issue you an RFE to say, they likely will issue an RFE saying, we know that your I-140 has been withdrawn. You need to have an offer of permanent employment in the United States, and they will ask you for a Supplement J. And Sam, what happens if you can't provide that Supplement J?
Well, there is a time that they give you. Normally, they give you the maximum time, which is, I believe, 87 days.
87 days on RFE plus
They do give you maximum time for the I-485. So you have 87 days, honestly, to go find a job.
Yeah.
If you're not able to find a job within 87 days, which is same or similar job classification to the job in the PERM labor certification, then you have a problem, because you're not able to respond to the RFE and submit a Supplement J showing that you had a change of employment. And if you're not able to do that, then the I-485 will be denied, and you hope that you're maintaining your H-1B, because the entire green card process is derailed. So what's the other scenario?
Well, if your priority date isn't current, USCIS isn't really going to be looking at your case. So
there has been, I'm gonna have to go back, I don't know how many years.
Occasionally, every now and again on 45 cases, we'll get a little something that says, "Hey, we want to update your file and give us, let us know that you're employed." It's possible.
If you recall, back in 2007, I believe 2007, when they made everything current, and there were thousands of adjustments were filed, USCIS consistently issued random and waves of requests for evidence to show that you have a job.
Yeah.
One of the things we haven't talked about and not in the slide, and that's probably worth maybe even a presentation by itself, is that you could supplement J into self-employment, into your own company. And that is something that if you're not able to find a job, you may want to talk to your attorney about how can I supplement J into my self-employment. So that's something that we've done successfully for other people in the past.
Yeah, that's an interesting challenge, though. I mean, because they do want to check on the bona fides of your offered employment, and that, well, like you said, it's a whole presentation, isn't it?
Yes, but it is very much doable.
So, Sam, this one's such an interesting scenario. I think it's for you.
All right. So I-45 pending, and the I-140 approved.
Yes.
Okay. But there's more to it.
Yes.
So before 180 days of the I-140, it was drawn so 180 days has not passed.
Yeah.
And within the 180 days of the I-140, the employer withdrew the I-140. However, the I-485 has been pending for more than 180 days. So when the I-485 is pending for more than 180 days, you can move to a new employer using Supplement J, as long as the new job is same or similar job classification.
Yeah.
In this scenario, though, the I-140 has not been approved for 140 days. So what happens? Because we've been talking all along about if the I-140 is not approved for 180 days, the employer can withdraw, you lose a lot of benefits, maybe you lock your priority date, but you don't kind of extend beyond H-1B beyond 6 years. So what happened if the I-485 has been pending for more than 180 days?
The I-485 pending trumps.
Yes. So in that scenario, it's an interesting scenario. So USCIS will give you a chance. So if the I-140 is withdrawn because there's a change of employer within 180 days and beyond 180 days of the I-485 filing, the USCIS will give you a chance. They'll issue a notice of intent to deny on the I-485. And they will give you a chance to prove that you have a new employer with Supplement J, through a Supplement J, and you have a job that is same or similar job classification, and you can continue your green card, which is amazing. I thought this is really nice.
Yeah.
Nice flexibility there for employees. But remember, it has to be same or similar job classification. And the last point is, obviously, if you are unable to find a job, talk to your attorney about whether I can create an LLC, a company or corporation, and I can take jobs and I can prove that I am now paying myself a salary.
Yeah.
You have to issue yourself a salary. You have to get yourself on payroll, have your own company pay you. And like I said, that has been done successfully in the past.
Yeah. The final scenario I think we have here is, I maybe got one more after this, but it's the Breathe Easy scenario. It's your I-140's been approved for more than 180 days. Your adjustment's been pending for 180 days, and good scenario. Your I-140 is approved. You keep your priority date. That priority date's always yours. Your I-140 approved more than 180 days means you get to keep it approved for the purposes of extending your H-1B status if you're eligible. And after 180 days, you can use that green card EAD/AP to move to another employer. You just have to file a Supplement J with USCIS to let them know that you have permanent employment.
So you're getting the easy ones, and you're giving me the difficult ones.
Sam, I think that is because I'm pretty sure the next one is one of those difficult ones as well.
All right, so let's go for it.
Yes.
All right, so all we've presented, we're going to throw in a layer of interfiling on top of it.
Interfiling.
Yes. So here's the thing. If you interfile, let's go back maybe can we go back a couple slides and then throw in the interfiling on top of it?
Yeah. So this is the 180 day.
After, so this scenario here, we talked about your I-140 has been pending for over 180 days, and your I-485 has been pending for over 180 days, and this is the wonderful scenario.
Yeah,
now,
you're going to make it seem less wonderful now.
Yes, I am. I'm sorry to do that. So now what's going to happen is you go in and say, I would like to downgrade my I-140 because you're in the EB2 to EB3 I-140, and I would like to interfile. So you file an I-140 downgrade, and you request to interfile it with your pending I-485.
Sounds good. Get it, switch to that new category, get a green card faster. Yes, sir?
Yes. Then you change employer. And what you did not know is that the 180 day on the I-485 resets, meaning that you are not entitled to file Supplement J immediately after interfiling. You have to start the 180 days of the I-485 counting from the date of the interfiling request. Yeah. And that's a big problem for you because the employer may or should probably withdraw their I-140 if there's no bona fide job offer. And they can also withdraw the prior I-140, and you don't have 180 days, and therefore could be a big problem for you. Now, if USCIS does not react, does not do anything until 180 days later, so the employer withdraws, and then the I-485 continues going, and there's no RFE, nothing is going on, and then 180 days pass on the I-485. So this is scenario 2.
Yeah.
So scenario 1 is if USCIS issues an RFE,
yeah,
and says your employer withdrew your I-140, what's going on with you? Please, here's a note on your I-485. Explain to us why this I-485 should not be denied because you do not have an offer of employment. At that point, you're in trouble because you have no answer. However, if USCIS does not do that and 180 days pass, and then they will give you an RFE on day 181 from the interfiling date, then you can hand them a Supplement J on that day and say, I have a job that is same or similar job classification. Here's my Supplement J. Please keep my green card going. And that would be a very lucky move if that happens.
Yeah, definitely happens.
Yes. So that's the kind of quick overview. That doesn't cover every scenario, and it does not discuss any scenario in full depth. This is kind of a teaser, if you will. So if you're in a situation, because, I mean, is the job same or similar job classification? And, you know, there's a lot of little details to this process that can affect the outcome. But that gives you at least a flavor of what's going on. So we got questions?
Yeah, definitely. Send your questions. I like questions.
Yes.
So please keep them coming. But let's hit
so you take the first one, I'll take the second one, Brian.
Okay. I understand the first one's always easy. The odd ones are the evens are hard. So it looks like we have kind of a series of them here, so we'll just read them as they come. So my previous employer filed AOS based upon direct EB3 approved I-140 while working for a different employer. So, okay, so you were working for somebody else, and a prior employer had an EB3 I-140, and you filed an adjustment based upon that. Got a receipt, free waiver for Supplement J, RFE for medical in April 2021 from National Benefit Center, fine. And my attorney has responded accordingly with the medicals in May 2021. Sounds good to me. Can I move to a new employer without joining the original company? However, I worked with them in the past 6 years.
So did he interfile?
No, it sounds like it was originally, it was like this. It sounds like Stephen here was originally approved. His I-140 was only ever in the EB3 category, and filed an adjustment, got some RFEs, and
he's giving you a date here. There was an RFE Supplement J. Well, I have received the receipt for fee waiver for Supplement J. There's no.
They always send out one of these goofy receipts that says, you know, we received your Supplement J, and they would have received one of your receipts because even though you might not remember filing a Supplement J, if your I-140 is previously approved and then you go to file your adjustment of status, you're required to file a Supplement J with your I-45. So that's why you get a I-45 supplement J receipt. So looks like your I-140 was approved for a while. Then you filed the adjustment.
Sure.
And normal stuff, you get RFE for medicals.
Sure.
And the final question is,
Change employer.
can I change employers? It sounds like it's been 180 days since your I-140 is approved, more than 180 days it seems. And it seems that your adjustment's been pending for 180 days. You're good to go.
Two things.
Same or similar occupation?
Well, number one, it sounds like he's very close to getting the green card.
That's true.
Okay, so that is a consideration. Now, I mean, we can answer the question, say, yes, you can move to a new employer, but once you file a supplement J, now you've kicked back the process.
They, we talk in terms of a documentarily qualified case. If they have a great big question, they have to evaluate.
Now you set back your process a little bit. So if you're close to getting your green card, obviously the challenge is that once you get the green card, you have to work for the employer for a reasonable period of time. You just cannot get a green card and just quit next day. And that's probably a discussion for a different day. But the answer is yes, on paper, you can change employer, but you have to carefully consider the consequence of that. If you got the medical, there was an RFE, if the priority date is current for you, you have to look at, am I going to get my green card soon, or am I going to delay my approval for a while because I changed employer?
Yeah, I would emphasize what you said, that it sounds like somebody is very close to getting into the green card. I mean, I see RFEs for medical exams, and then a month or two later, I see a green card approval. I can think of a couple cases recently.
Now, it could be a situation where he doesn't have a choice.
Well, yeah.
I mean, if you don't have a choice, the employer said, "I don't have work for you. I'm sorry. I cannot issue you paychecks anymore. I don't have. It's pandemic year. It's a really bad situation." Yeah, file supplement J. You got to do it, but obviously you got to do it through counsel because supplement J is technical, highly technical.
It's that same or similar occupation, which you really got to have somebody, help you think
Most
about.
of the time they move to the same job. I mean, but you have to be careful. There's some tricks to it. You have to be careful. Just through counsel, the cost of getting counsel versus the benefit of being protected is just, the benefit is huge, much outweighs the cost. So, yep, sounds good. So
we move onward, I think.
Yeah. What would you suggest? All right, file the I-45 supplement. Is this the same gentleman?
No, it's a different one.
This is okay. Puneet Joshi. What would you suggest? File the I-45 supplement J before joining the new employer or after joining the new employer? What is the best approach? You have to have started with a new employer, really. The employer has to say they have a job for you. I would put all the paperwork ready and file it on day one. That's the way I feel about it.
Yeah, I mean, make it part of your onboarding package at the new company because, I mean, you're going to need somebody. You're going to want. You can't. How are you going to? If you're not familiar with Supplement J, it has to be signed off by your new permanent employer, and they have to be able to. They ask, well, one, you need somebody to sign that. And two, they ask, when you joined the company, and are you employed and did you join? And in theory, you could answer. You could have a one outwards, but you need them to sign the form.
On day one, have it ready. Have them sign everything the morning off with your FedEx envelope, and then send it to your attorney on the same an hour later. Get it out in the mail on day one. Yeah. That would be my recommendation.
Yeah, when I talk to people about this a fair amount, and they say, how do I bring this up? Bring it up early. Your need for a supplement J, because some companies are squirrely about immigration stuff, and if you come to them and they say, well, I need to sign this immigration form. What, permanent employment? I've seen some people have problems with that.
Well, it depends on the situation too. So if you have options, like your job is okay, you just found a job that pays you so much more, or close to home, or personal situation that's really improved your situation, then I would negotiate before I accept the job. I would put everything on the table up front. If you got into a situation where you lost your job and you are in a situation where you really don't have an option, now you could roll the dice and take the job on the EAD and then show up early every day, work a little late every day, smile at everybody, let them like you, and then a month later go show up and say, I just need you to sign a piece of paper for my green card.
Yeah.
So it's a strategy. It's on a case-by-case basis.
Yeah, you really got to sort of play it cool and judge what's going on there.
Yep.
There's another question here, and I think it's my turn. So I have a valid H4 EAD till December 2022. I received the green card EAD recently. Which one should I use for applying for work? What are the pros and cons of both EADs? Well, my favorite thing to say is if you begin using that green card EAD, you will abandon your H4 status. Now, for a lot of people, generally, when you think of it as two layers keeping you inside the United States, your non-immigrant status, your H1, your H4, your L1, your L2, etc. That allows you to live and in some cases work inside the United States, makes you happy, makes life good. Having a pending adjustment status, pending adjustment status allows you to live in the keep on living in the United States while it's pending. Having a pending EAD and advanced parole, they allow you to work and travel. Fantastic. If you use your green card EAD while you're on H4 status, you're effectively abandoning your H4 status. So, I mean, that's really, as I see it, is the big downside of using the green card EAD. Practical
cons?
The cons?
There are no cons.
Yeah, I mean, they're perfectly. I mean, here's some challenges. The problem with the H4 EADs is those things expire and they're taking a long time to get processed right now. One of the common challenges we're having around here is, I filed if you guys go online and look on the USCIS processing times for an EAD for an H4, it's like 7.5 months. And when's the earliest they allow you to file an H4 EAD? About 6 months out. People aren't getting their EADs fast enough. It's my general, my super cautious guy advice for those adjustment EAD advanced parole is put them in a drawer and keep them for when you need them. And if you can't keep your H4 EAD going, heck yeah, keep yourself working and pull that green card EAD out of the drawer if it's important to you. But
for the H4, it really doesn't matter. It's the H1B that's really
this is true. I mean, you can't really screw up your H4 status.
I mean, let's assume, yeah.
Your H4, your derivative status is your derivative status. It's really contingent upon your spouse's primary person status.
You're splitting hair.
Yeah.
It doesn't really make a difference. You have both of them. I would try to stay on H4 if I can. Yeah. If the H4 EAD runs out, use the green card EAD. Just remember that the spouse now, or the child, if the child, your son or daughter is working, then they're no longer on H4, which it's not the end of the world because they can leave and come back.
Well, that applies for when the primary visa holder, if the H1B holder jumps onto their green card EAD, they abandon their H1B status, and thereby the family loses their H4 status. If the person who's on EAD H4 uses their green card EAD, doesn't affect the primary H1B holder.
Now here's the thing that you should remember that's really critical. If the H4 works on the green card EAD, they're no longer on H4. If they leave the country and they do not have a valid advanced parole, they've abandoned their adjustment status.
Yeah.
And it's a big problem.
Yeah.
So if you have a valid advanced parole, there's really no issue. And now they're obviously approved at the same time. But if you are on green card EAD without an advanced parole, you cannot leave. Practically speaking, leaving the country could be considered abandonment.
Yeah, I mean,
it's hard for USCIS to catch it. It's not easy for them to catch it, but it is just risky. In the reality of the matter is when you submit all this paperwork in the H4, they're probably not going to see. They're not going to know whether you work on the EAD for the green card or you work, unless they go to the employer and look at the employer's I-9, which they never do. So these are theoretical discussions, not practical discussions, to be honest with you, situations. You got 2 EADs.
Well, I got to talk about a big pro of the green card EAD, which is you can take advantage of it if you see it's automatic extension of green card EADs. When you do I looked this up after our last because I like to be 100% sure rather than 99% sure. If you USCIS basically, if you timely file your green card EAD extension, they give you I believe it's 180 day. Well, see that's something I don't have in front of me. I have to look it up. But
there are benefits, but you can be on H4 EAD and take advantage of the whatever relief on the. You can switch back to the green card EAD.
Yeah, it's called my H4 EADs are run out, and I don't think I can't get a new one timely. I get to hop on the green card EAD, and there you go. Keep your green card EAD valid, even if you're not going to use it though.
So we confuse Corona. Let's make it simple.
Yeah,
it really doesn't matter. I personally prefer to start with the H4 EAD. Do you agree?
Yeah.
You agree on that?
Yeah.
Start with H4. Keep your H4s, not a big deal. But and don't hesitate to use your green card EAD if you get in a situation where the H4 EAD runs out.
Yeah.
Is that a good answer?
That's a very concise answer.
And if you're traveling outside the U.S. at any time, consult with your attorney before you travel, just to make sure that there's no negative impact, and share with them that you've changed employment, you're using the green card EAD. Just share these details with your attorney so they can advise you whether there's a concern with the travel or not. So that would be a good summary.
Yeah.
All right, sounds good. All right, let's talk to Raj here. Is that my turn or your turn?
I believe it's your turn.
No, I think it's your turn.
I'll be happy to do another. If I'm in an I-140 downgrade EB2 to EB3 process, the EB2 is approved more than 180 days, so that's probably a pretty old one, and the EB3 is still pending and more than 180 days. Can the employer still have the chance to withdraw the EB3 I-140? So
there's a piece of information missing here. That
where's your adjustment?
It's at the same time as the EB3.
I presume so. Yeah.
Okay. And the adjustment of status was filed at the same time the EB3 downgrade was filed, and both are more than 180 days.
So the EB3 has never been approved, but there's no adjustment filed based upon. The EB3 has never been approved, is what I'm gathering here. EB3 is still pending, but EB2 is approved, and your adjustment is based upon the EB3 case. Your EB3 I-140 can be withdrawn, and that can cause everything to fall apart.
Yes.
Yeah.
So the passage of 180 days on the adjustment of status without an approved I-140. So, for example, if there's a financial ability question that comes up, and the employer is not able to respond or not respond to the RFE, the I-140 will be denied. I don't think you can do supplement J. Yeah. Even though 180 days have passed.
Yeah.
On I-485.
Here's a question though. Can you interfile and get back, jump off your?
But that's another interfiling. So
you have to restart
the clock. Now, remember, interfiling is discretionary.
That requires EB2 priority to be current as well. Yeah.
And that's the problem with interfiling. That's the problem that I don't like interfiling, is because did USCIS accept the interfiling? The USCIS did not accept the interfiling. They don't tell you.
And the way you find out is you get a NOID or denial notice on your I-485.
Yeah. So let's replay the scenario for Raj. Okay, let's replay the scenario for Raj for everybody to kind of see what happens. So you file an I-140 downgrade from EB2 to EB3.
With the I-485 at the same time.
And you do not interfile. You file an I-485 for both, right? So the EB2 is approved more than 180 days. So, but in this case, he's probably EB2 is not current yet. That's why he's down.
Yeah, that's exactly.
Yeah.
But EB2 might be current now.
But by interfiling, okay, if the EB2 is more than 180 days, that remains. He cannot withdraw the EB2. He can withdraw the EB3. So the adjustment is denied, the EB3 is denied, the EB2 I-140 more than 180 days cannot be denied, can
be withdrawn rather.
Cannot be withdrawn. I'm sorry. Yeah. And the H4 EAD can be issued based on that, and the H1B extension beyond 6 years can be issued on that.
Yeah. So lots of.
That's a good question, Raj. Thanks for bringing this up. That helps us out.
Yeah.
All right, so let's go into the next one.
Yeah, from CBAM. So it's I have not received my EAD AP, and my date is current from July 1st, 2021. I presume that means priority date. And there's been no interfiling.
I've never seen it in the current. Okay, and there's no interfiling and no interfiling. So
well, this is. I mean, we took Stephen's question.
So we see that. I mean, yeah.
Yeah, it is, for some people, it is a reality that we are seeing green cards getting approved before EADs/APs. I know this is kind of actually like follow-up information, I think, from the question he asked, but doesn't surprise me at all. I mean, you're that scenario right there. Your priority date's current on July 1st, 2021. And as I recall, we were talking about Stephen's case being sounding really documented, really qualified. Got an RFE for medicals already. And let me guess that, I mean, that would have come in late May, maybe probably like late May. It sounds like somebody's green card is imminent.
The scenario of green card approval without an EAD and advanced parole is common in the family-based petitions for decades. This is something that we're in the employment-based application, we're seeing some of that because they're so overwhelmed and backed up in issuing the EAD and advanced parole, and therefore they'd rather approve the green card, and then that saves them the work on the issuing the EAD and the advanced parole. But for family-based petitions like spouse petitions, it happens all the time. It's very common for years and years. So yeah. No big deal.
Go down there. There's Vishnu G.
All right, so can you file multiple I-485 applications with former and current employers if final action date are current in both EB2 and EB3?
I love this question.
And this is the yes, and yes.
Yes. I mean, both have to be willing to offer you permanent employment in the United States. Both of them have to be saying, we want Vishnu, but...
And you have to say, absolutely, upon green card approval, I will work for you. And if I get another green card, I will withdraw my acceptance for the other person.
Yeah.
So 100%. That's the beautiful scenario.
I love this scenario. It's you just have two horses racing, and they both have your name on the side of it.
And you don't have to deal with interfiling and discretion, and USCI is telling you this, and just life is easy. I know it costs a little bit of money, and we're all about saving, but this is your green card. So this is my preferred scenario. File them. Yes.
Yes, I love it. What do we got? Who took the last question, Sam?
Husband and wife on H-1B. Wife received green card EAD, okay, as dependent. Pros and cons of using green card EAD. Okay, so husband and wife on H-1B. We've seen that a lot. She received green card as a dependent. Well, I mean, number one, if you can keep your H-1B, that's wonderful because it gives you the flexibility if that green card falls apart. So now you're creating a pyramid on one foundation, which is your job. And if that pyramid falls apart, you have nothing to fall back on. So let's assume you lose your job. If your wife is on H-1B, you can get on H-4.
That's what I really like about this scenario. It's called, if something falls apart for the husband, the wife can he can jump on H-4 through the wife, and something falls apart for the wife, she can jump on H-4 through the husband.
And we've done that.
Yeah.
And honestly, here's this is a true scenario. I had a husband and wife, both were working for the same employer, both were on H-1Bs. And both were laid off on the same day. Both had green card applications, PERM and I-140 approved. They were smart to listen to me to do that, and both had I-485s. And what we did is we've created a company for one, and then the other person worked for the spouse. So, and we pushed the employee green card forward, and we withdrew because one was kind of more of an executive position. The other one was more of the professional position. And we pushed it through and both got the green card. We ran these horses together. And when both were laid off at the same time, we were able to figure a scenario to save the green card. So creating multiple options for you, it expands your ability to deal with unexpected scenarios. And this is really critical for your survival during this very unexpected time that we're living in?
Yeah, I can think of a scenario I dealt with. It's a fellow who was EB1 green card, and he was so close. And then his employer said, "We're shutting down that division of our business. We're happy to send you back to your home country." And instead of it's both of them having H1Bs in the past, suddenly it's shoot out an H1B for him, H1B for her, and finding ways to keep them in. Just having both being people who haven't been on H1B status is just an awesome way to, it's something. We're talking about these nightmare scenarios, and obviously a lot of people just have normal green card cases and they're successful and things are good, and you don't have to worry about your H1B getting denied, double H1B denials. But it's having those things in your pocket is just. It's good. It's good for when you come to an immigration attorney and you need it. It gives us options to work with.
So for MSR, husband and wife on H1B, wife received green card as dependent. So pros of getting the green card EAD obviously is she's flexible.
Work for anybody.
She can work for anybody. She can work for part-time. She can work for herself.
Yeah,
himself,
no. I mean, H1Bs are portable, but scary. Coming to a new employer and saying, "I have to file an H1B for me."
It just really makes her very I mean, not everybody wants to file an H1B and do a green card. So if you have a green EAD, she can take vacations, maternity leave.
Dependent green card EADs are even better because they don't have to worry about supplement J portability for using them. She can do what.
Sky's the limit.
Yes,
exactly. Sky's the limit. Okay. So now here I will change the scenario. Husband and wife have H1B. Wife received green card EAD as dependent. Pros and cons of using green card EAD. Have your wife do a green card EAD and start her own company.
Yeah. Do that.
Now you have the possibility of supplement J into employment into her company. Should you lose your job. So now you've created options for yourself. So those are the pros. Cons of using green card EAD, we've been talking about the cons, obviously, that if you lose your job and she's just having just a normal everyday job, she also loses that job, and both of you have issues unless you supplement J into a new job with same or similar job classification, in which case you'll be fine.
Yeah.
All right. Sounds good. So Raj has a question.
Raj has a follow-up on his previous question. And in terms of questions, people, keep them coming because I always like a good brain teaser.
Yes. With I-45 pending, this is yours.
Okay, so I have to refresh my memory on Raj's question above. So I'm going to clandestinely scroll up here, and we're going to look at it again. So Raj, I-140 downgraded EB2 to EB3. Basically, probably last October, he would have filed EB3 downgrade and adjustment of status together. Approved more than 180 days. EB3 still, EB2 is long approved. EB3 still pending. And can the employer withdraw the EB3? So with the I-45 pending, for my question above, can the employer still withdraw for no reason, not before getting an RFE before the EB3 I-140? So yes, the employer can withdraw your I-140 EB3 downgrade that is supporting your adjustment for any reason. And really, it's only when that I-140 gets approved is when you you can take advantage of the pending adjustments, that little loophole that adjustment of status pending for more than 180 days trumps the I-140 180-day limitation. So assuming your adjustment status has been pending for more than 180 days, once that I-140 has been approved, that's when things get to start, feel a little bit safer.
It has to be similar job.
Same or similar
job classification. So just to kind of explain that to everybody, the Department of Labor have classifications like information technology, engineering. So there is a list of classifications that are available that they published. Within these classifications, the job has to be in a progression. So you could be in a senior level, but in that progression of the job. So if you're going in as a business analyst, but your next job is an accountant, that's not a same or similar job classification. So you have to be very careful with that. So what you want to do when you're changing employment and using Supplement J, start with getting a copy of the job description for the new job. That's really important. Take it to your attorney and say, here's my PERM job description. Here's my new job description. Is this same or similar job classification?
Yeah, I think an attorney is a perfect person to go to, because in terms of, I like computers, but I'm not an IT person. As somebody who usually reviews these sort of things, because ultimately you're handing that over not even to an immigration attorney who handles that. You're handing it to the government. They have to make a call, so they can give you an insight as to how what it looks like, really.
So there was a question earlier that was asked: what if my employer does not give me the labor certification?
Oh, there was a question asked. Oh, that's a great question. It is possible to get copies of those FOIA requests. They are public records,
and it's almost like an email to the Department of Labor. So just research FOIA,
Freedom of Information Act. Yeah,
Department of Labor, and then just look at the instructions, and you should be able to. They used to publish those, and now they stopped publishing.
Well, it's as
redacted and hidden.
You can get them. You can get the details of a labor certification online right now, but it's a nightmarish Excel spreadsheet, which is really fun for me as a labor certification attorney to parse through. But for the average person, it's not particularly useful. But you can do a FOIA from the Department of Labor. You can also do a FOIA from USCIS to get a copy of. We can get a copy of.
Department of Labor is a lot quicker, though.
Yeah, but sometimes people
you do both.
Yeah,
you can do both. So you need to work with your attorney to get a copy of. Most employers do give these job descriptions. Say, okay, here's the job description we've used.
Yeah.
Okay, and you don't need a copy of the labor certification to do Supplement J. You only need the job description, because the U.S. Department, you can just say, my employer for policy reasons unable to share, but here's the job description I was used in my job, and then you can argue it, and then they'll look up the record.
Yeah, they have. Yeah.
But you can also do a Freedom of Information Act request to get that record. Sometimes companies shut down, and you don't have a copy of that list.
That happened. Yeah, I've had that one happen.
Or get sold, and then the new people don't know who you are.
Who are you? Yeah. That's probably more common than the at a business one. It's called, well, you work for company X and we're company Y, and we brought their records, and your company had a policy, our company has a different policy. It's called, you don't get a copy.
Exactly.
Yeah.
Which is, companies have their own policies.
Yeah.
You're just gonna have to work around these policies, respect the policies, and work around it. You're moving on. You've moved on. You need to prove same or similar job classification. Get your attorney to help you to do what needs to be done. Most companies will provide you what you need, especially if you've done good work for them, and given them reasonable notice when you leave. Obviously, I'm not teaching people how to relate to other people. That's not my job. I guess I'm a lawyer, but it's my experience is that as you build relationships and how you begin employment and how you terminate employment, makes a big difference.
Yeah.
in terms of making your green card process easier. But we got more questions here.
Yes. There we are.
When does I-45 countdown actually starts for 180 days? Is it when USCIS receives application or when USCIS receives biometrics? It says biometrics received in April 2020 for I-45 application. It's when USCIS receives the application. And really, it is when you can prove it by FedEx that they have received it. And sometimes there's few days discrepancy.
Yeah, I mean, to say, well, check your receipt notice, but I mean, when all those cases are filed in October, it took them months to get receipt notices out the door. Raise your hand if you didn't see your receipts for your I-45 until January. Yeah.
Yeah, my goodness, right?
Yeah.
It's just like, wow, they haven't opened that box for 6 months. It's been sitting there. What is going on?
Yeah, the 180-day time frame kind of stinks, because they're not getting people those EADs in 180 days. That's what bothers me about it.
Well, I mean, what bothers me about it is if, they've settled this lawsuit because they were rejecting cases because there's a box empty, like a little square box, not checked, which does not need to be checked. But if you put NA, you did not put NA on a box that's inapplicable, left it blank, they were rejecting it. They settled this lawsuit because they got sued for it. A small box. But a big box with files and applications sitting in their warehouse for 6 months, that's okay.
Yeah.
They don't even touch it, and that's okay, that's fine. But you missed a small box. We're packing this application, and we're shipping it back after 4 months is ridiculous.
Yeah, well, I mean, how was it taking that long? Because as I understand it, they were essentially pre-reviewing these things and then determining whether or not they're going to reject the case.
Pre-reviewing it to find reason to deny,
Yeah.
to not accept it. And they cannot review it unless they cash a check. I mean, it's business. Like you hire me as a lawyer and say, well, if the case is approved, I'm going to pay you. If the case is not approved, that's not how we work as lawyers.
Yeah.
Right? You pay me, I work on the case. Same with the government. We write them a check to review it. No, they're reviewing it to find a reason to reject, and then they decide to reject the case and hand you your check back, which I've never seen ever before until this.
Fingers crossed, knock on wood, pray to your deity of choice we'll never see it again.
Yeah, it's nuts.
Yeah.
All right, so I think we've answered the question for Mr. Kulkarni.
Yes. So follow up to Vishnu's question.
All right.
I-140 EB3 pending with former employer. Current employer EB3 I-140 is approved. Hence, I can file the entire new I-45 with him and send medicals since it's final action current. And the answer is yes. If somebody has an approved I-140 EB3 for you, still approved, they never withdrew it. You gotta look into that, obviously. Yes, you can definitely file a second. We've talked about that scenario. We love that scenario. To just got to make sure you have a legit, bona fide offer of permanent employment from all employers.
I just don't like interfiling. I'm sorry, it's not. I mean, people think, well, you're a lawyer, you make more money because you file an adjustment. Honestly, that's not what it's about. It's just the interfiling leaves. I guess I've seen so many things in my lifetime that goes wrong when the government, when you leave
left to their own devices.
When you small little opening for them to
oh, don't worry, the government has it taken care of.
Yeah, we'll take care of you. This is the first immigration attorney that ever showed up. The first attorney that ever showed up before USCIS or was
the first immigration attorney.
INS.
Yeah.
Back 60, 70 years ago, they said an attorney for an immigrant. That doesn't make any sense.
Take care of you.
They said we'll take care of you. We are here for the immigrant. We don't understand why an attorney should come in with an immigrant. It's the whole agency is to deal with him. So they were shocked that a lawyer showed up with the immigrant as the first attorney ever represented a client before the INS when immigration became more intense and more complicated. And now we have 50,000 immigration lawyers in this country.
Really?
I don't know what the number is. Maybe 20,000. I don't know. But
1, 2,
yes.
and all the other ones out there.
That's right. So let's go in here to the next question.
Yes.
Spouse on H4 can use.
I think we have I think that one came out a little bit premature. Here we are.
Our attorney says spouse on H4 can use adjustment status EAD, and it won't negate H4 status. Is that correct? Main applicant continues on H1B. If you use your EAD, you are outside your H4. So it could be a misunderstanding, and it could be that there are other facts. I mean, we don't want to say anything negative about other attorneys. I have tremendous respect for all, and everything is about the details of the case.
Yeah.
So there's probably more to this question than the 7 words in front of us.
Yeah.
So
I mean, generally speaking, for any sort of non-immigrant, there's certain rules for any non-immigrant status, and you have to comply with those to maintain your status. And
I mean, the argument probably they're making is that they're H4 and they're permitted to work on EAD, so they're working on. But and that's probably. I mean, I like what this other attorney is saying,
because who's looking at the I-9 records?
The discussion is, like I said, is highly theoretical. This is a law school conversation. This is not a a practical situation. But you go in to the employer and you hand the employer the EAD card for the green card. You hand that card to to the employer. You don't hand the H4 card. You hand the green card EAD to the employer, and the employer takes it and then makes a copy of it and
I-9 complete, yes.
I-9 complete, and then keeps it in his file, and then you file your H-1B petition. USCIS will never know.
There's no government officer living in the drawer where they stow
that document is. So for them, they may never know that which EAD of the two did you use.
Yeah.
Now, right? Now, you're employed more than 180 days, because I'm not going to talk about INA 245K. So I'm going to take that equation out of it. So you're working for a year and a half, okay, on EAD, green card EAD, and you stop renewing
the H4 one,
the H4 EAD. I don't see how you can make an argument that you're maintaining your H4.
I mean, I'd love to try to make one, but I mean, ultimately, my off-the-cuff answer is working is incompatible with H4 status unless you have an EAD in hand for H4.
So, but again, there could be more facts, and your attorney is advising you on a specific question that is not the question in front of us. So that's probably the best I can do on that one.
Yeah.
All right. So 701. So we're gonna take a couple more questions here, and then we can go from there.
Yeah.
We file new I-45 with current employer. We'll file what? What's that one?
It's follow-up from Vishnu on. I think he's just giving us a little bit of clarity, but we have trouble seeing those things.
Okay. So using advanced parole, can we travel outside the United States and come back? Will travel ban apply to advanced parole travelers? Can you please share your thoughts? Well, short answer, yes, it does apply.
Yeah.
A longer answer, look at the exceptions.
Yeah.
Because if you're a parent of a U.S. citizen child,
under age 21, unmarried.
Well, a child by definition.
Yeah, this is true. Yeah.
A child, what's the definition of a child under immigration law? Is an unmarried under 21. A person unmarried under 21 who is your son or daughter. So if your child is a U.S. citizen, then you're not subject to the proclamation. But if and other exceptions, there's other exceptions. So look at the proclamation. So the short answer, yes.
Yeah.
Subject to the proclamation.
Yeah. I got to say that travel ban was really contingent upon where you're going. I mean, it's what countries have a travel ban in place. India has one, the entire European Schengen free travel zone, Iran, Brazil, I believe still. Those are the places you have to deal with.
Yes.
About that.
Yes. 703, thank you guys. Hopefully this was helpful. And if you have any follow-up questions, you can throw in our contact information below Brian here before we turn it off.
Bam.
All right, so contact at immigrationvisaattorney.com. Sam Shihab, have a great day.
I'm Brian Burke. Thank you.
Take care.